Good morning. Today we are going to see one more problem question on proprietary estoppel. Let's move on to the next slide. The video content has been made available for informational and education purpose only. Kindly go through the disclaimer completely. In most of the cases, problem questions on the proprietary estoppel, the questions will be like this, like a couple will buy a property on one name, and one will contribute for the purchase of the property, the other will contribute for the upgradation, and finally they will get separated. Once they get separated, the issues will pop up one by one. Let's see what is in this problem. Jack was the sole owner of the freehold title to a house on the registered land. After meeting on a holiday, Jack and Diane began a relationship in August 2013. In March 2014, Jack asked Diane to move into his house with him. This required Diane to sell her home for £125,000. Diane was concerned about her rights after she moved into the Jack house. In April 2014, after an evening drinking wine at Diane's birthday dinner, Jack said to her, "You can think of this as being your home too. I want us to have a meaningful relationship." This statement is a very key term in proprietary estoppel. Diane had a son, Billy, from a previous relationship. Billy was aged 5. He had to move a school as a result of this move. Diane wanted to pay for the house to be redecorated so that it was more to her taste. In March 2015, she asked Jack to give her permission to do this because, as she put it, that would make me feel more like this is my home too. Jack allowed her to refit the kitchen, the master bedroom, and its ensuite bathroom at a total cost of £40,000. Diane paid for the entire £40,000. The house had 5 bedrooms and 8 other rooms. In March 2016, Jack decided to construct a guest house on the land attached to his house. Diane was a qualified architect. She designed the bungalow. It was a single bedroom bungalow in the modernist style with a kitchen and a living room looking over the large gardens. The bungalow was special in that it required no heating and received all of its power from solar panels on the roof. These features were the results of Dan's special knowledge and skills as an architect. Dan supervised the construction of the bungalow. The construction work cost £100,000, which was funded half by Jack and half by Dan. Dan supervised every stage of the construction process and fitted the solar panel herself. The work was completed 4 months ago. On regular occasions during the construction work, Jack said to Dan, "You are amazing. No one else could do what you do. This really is your guest house." Recently, Jack has begun a new romantic relationship and wants Dan and Billy to leave the property. We have to advise Dan on her rights under proprietary estoppel principles. First, we have to establish the estoppel. The key elements of proprietary estoppel are the representation or assurance made to the claimant, reliant on the representation by the claimant, and the determinants suffered by the claimant as a result of the reliance. For example, Turner versus Major case. Let's start with the assurance. Jack made a clear assurances to Diane that she could consider the house as her home and that the guest house was her guest house. Come to the reliance, the Diane relied on these assurances to her determined by selling her own home, spending significant sum in renovating the Jack's house, and designing and supervising the construction of the guest house. The third one is determined. Dan incurred substantial financial and personal costs in reliance on Jack Assurance, including the sale of her own home, renovations, and the guest house construction. To stress on the same points, the assurance by the Jack. When the Diane moved in with the Jack in 2014, Jack told her, "You can think of this as being your home too. I want us to have a meaningful relationship." This can be seen as an assurance by the Jack that Diane would have an interest in the property. The reliance undetermined. Diane sold her own home for £125,000 to move in with the Jack, which represent a significant determinant. She also spent 40,000 to renovate the property, further demonstrating her reliance on Jack's assurances. What about the Diane's contribution? The Diane designed and supervised the construction of the £100,000 guest house on Jack's property, contributing her skills and expertise as an architect. This can be seen as a further determinant at Jack's encouragement. During the construction of the guest house, Jax repeatedly told Diane, "You are amazing. No one else could do what you do. This really is your guest house." These statements can be seen as further assurances that the property was intended to be for Diane's benefit. Jack made a clear representation to Diane in April 2014, stating that, "You can think of this as being your home too. I want us to have a meaningful relationship." This suggests that the encouraged Diane to believe that she would have the rights in the property. The reliance, Diane relied on his representation by selling her own home for £120,000, as we have seen earlier, and moving in with Jack, which required her son Billy to change the school. Determined, Diane's action of selling her home and relocating with her son constitute a significant determinant. Unconscionability, it would be unconscionable for a Jack to now deny Diane any right in the property, and given his clear encouragement and Diane's determined reliance. Based on the precedents of Fascio versus Tanner and Gillette versus Holt, the court may grant a Jan a property interest in the property, either in the form of the freehold or a combined award of proprietary rights and monetary compensation. What are the factors we have to consider in determining the remedy? Dan's significant financial and personal investment in the property, including the £40,000 she spent on the renovations and her contribution to the construction of the guest house. Jack's repeated acknowledgement of Dan's valuable contribution, stating that this really is your guest house. The length of Diane's occupation and her role in the property development, the potential disruptions to Diane and her son's living arrangements if they were required to leave the property. In 2014, the representation on the reliance, how we will see how it is heavy or weak. In April 2014, Jack told Dan, "You can think of this as being your home too. I want us to have a meaningful relationship." This statement could be considered a representation by Jack that Dan would have some form of proprietary interest in this house. Further, Diane relied on this representation by selling her own house for £120,000 and moving into Jack's house with her son Billy. The representation made by Jack in 2014 was quite vague and did not clearly promise any specific proprietary right to Diane. The case of Gillette versus Holt suggests that the representation must be clear and unequivocal to give the rise to an estoppel. However, Dan's determined reliance in selling her own home and moving in with Jack could potentially support a claim of proprietary estoppel. The case of Crab versus Arun DC indicates that even a vague representation can be sufficient if the claimant has suffered a significant detriment. Overall, the 2014 events may not be sufficient to establish a strong proprietary estoppel claim, as the representation was relatively weak and the detriment, while significant, may not be considered enough on its own. Let's see what happens in the next 2 years. In March 2015, Dan asked Jack for permission to redecorate the house, saying that would make me feel more like this is my home too. Jack allowed her to refurbish the kitchen, master bedroom, and the ensuite bathroom at a cost of £40,000, which Diane paid for entirely. The redecoration work could be seen as a Diane's further reliance on Jack's earlier representation that she could consider the house as her own home. The 2015 events demonstrate a more concrete representation by Jack, as he explicitly allowed Diane to make a substantial improvements to the property, indicating a continued assurance of her rights. Diane's 40,000 investment in the property can be considered a significant determinant, as seen in the case of Axley versus Gods, where the court found that the claimant's expenditure on previous improvement was sufficient to establish an estoppel. The combined events of 2014 and 2015 may be stronger in establishing a proprietary estoppel claim as the representation and determinant becomes more substantial over time. Further, in 2016, in March, Jack decided to construct a guest house on the land attached to this house. Dan, being a qualified architect, designed the bungalow, which had several innovative features, and supervised the construction, which was cost £100,000, with Jack and Dan each contributing half the cost. During the construction, Jack repeatedly told Dan, "You are amazing. No one else could do what you do. This really is your guest house." So, the the 2016 events demonstrate a strong representation by Jack, as he explicitly referred to the guest house as your guest house and praised Diane's significant contribution to its design and constructions. Diane's substantial involvement in the design and the construction of the guest house, as well as her financial investment, can be considered a significant determinant, and similar to the cases of Trauner versus Major, where the court found that the claimant's work on the land was sufficient to establish an estoppel. So the overall conclusion is the combined events of 2014, 2015, and 2016 present a strong case for Diane to establish a proprietary estoppel claim over the house and the guest house. So, what are the potential remedies based on the principle established in the case law, such as Jennings versus Rice and Stake versus Down, the appropriate remedy to fire Diane's proprietary estoppel claim could be a monetary award representing the value of her contributions and detrimental reliance rather than a direct transfer of property ownership. We have to consider the overall fairness and proportionality of the remedy to determine the suffered by Diane. Determined. In Henry versus Henry, the Privy Council emphasized that the court must weigh up the determinant and benefit to the claimant in determining whether has been a sufficient determinant. Diane's sale of her own house and her son's need to change the school represent a significant determinant. In Sugit versus Sugit, the court found that the claimant determined, even if limited, can still justify a proportionate remedy under the proprietary estoppel. In Southwell versus Blackburn, the court recognized that determinant should be assessed over the course of the relationship, not just a narrow technical concept. So, what is the impact on third parties? Under the Land Registration Act 2002, an equity by estoppel can bind the successors entitled to the property, provided it is properly protected by entry of a notice on the land register or by the actual occupation. If the court grants then a freehold or easement interest in the property, this would bind any future purchasers of the land. However, if the remedy is a license or financial compensation, it may not bind a subsequent purchaser. Unconscionability. Based on the principle established in the cases such as Taylor Fashions Limited versus Liverpool Victoria Trustees Co. Limited and Mathura versus Mathura, the doctrine of proprietorship may still apply even if Jack was unaware of the true legal position at the time. The holistic approach adopted in Gillette versus Holt and Jennings versus Rice suggests that the court will consider the overall circumstances to determine whether it would be conscionable for Jack to insist on his strict legal rights. So we are going to conclude. In conclusion, while the 2014 events may not be sufficient on their own to establish a properly estoppel claim, the combined events of 2014, 2015, and 2016 present a strong case for Diane to assert her rights over the house and the guest house under the principles of proprietary estoppel. Hence, today the problem question is very straightforward, and by applying the principles of proprietary estoppels and the case law precedents, we can prove that Diane has rights over the house and the guest house under the principle of proprietary estoppel. Thank you.